Good afternoon. This is the Board of Standards and Appeals Public Review Session for January 26, 2021, 2 p.m. session. There is no public testimony during the review session. The first item up is zoning calendar, new cases, item number 24, 2019-301BZ, 148 26th Street, Brooklyn.
Okay, we have proof of service of initial application to officials and of notice of hearing to officials and neighbors, and proof that there was posting in the lobby. The community board recommends approval. We have one letter of objection from a nearby property owner concerned about crowds and noise. We have one letter in support. We have DOI. Fire department's letter of no objection states that the space requires a PA permit and that the fire department will inspect. The description of the site in the statement of facts is incorrect. It's saying the site's much smaller than it is. It's a 60 by 101 foot 2-inch site, so they need to correct that. The certificate of occupancy and proposed Schedule A on BIS state there is a caretaker's apartment on the second floor, while the statement of facts says there are two, quote, art studios on that floor. So I ask, are the so-called art studios live work, which you might find a lot of in this neighborhood? And if so, what has this CrossFit done to protect this ultimately residential use? It functions as a dwelling unit from intense vibration and noise. No acoustical information was provided on the drawings at all. And I actually didn't find anything in the statement of facts. The other thing that I saw was there was an application filed in 2015 to construct a mezzanine in the building. I don't know if that was a legalization application. It was not approved. Is there a mezzanine in the building? And so there's also, when you look at the building from the exterior, it looks like it's 3 stories, but based on the drawings, it seems that there's a 25-foot ceiling on the first floor, which is why they might put a mezzanine in there. And I'm kind of assuming they did. If you have such great ceiling height, and a CrossFit doesn't need that kind of ceiling height, they don't have, like, it's no climbing wall or anything like that. So those are my questions. Vice Chair Shanda.
My questions are with regards to sound, if there is any live music that is played on site, and if sound limiter, and what kind of sound attenuation measures have been taken.
Not live music. Music. Not
Yeah,
live.
I'm sorry. I meant music while somebody's there. Yeah, not live, but live, like music. Yeah, thank you.
Commissioner Ollie Brown.
Other than sound attenuation, no other questions.
Commissioner Sheta.
Thank you, Chair. They are saying that it did open in 2014, and I'm not sure, is this accurate? It's open since 2014, and now they are coming for a legalization.
I see it from the highway when you're driving.
No, but 2014, we know it's a legalization.
Yeah.
But I don't think we have information on when it opened.
Yeah.
Other than,
Yeah, and the sound attenuation, they said nothing about it, and we need to get some interior photographs as well. That's all. Thank you.
I think they provided interior photographs. They did.
Yes, they did. It
They
was a
did?
last-minute submission. I think it was on Friday.
Oh, maybe that's why I didn't see him. Maybe.
No, there's definitely, so you get a good sense of what kind of equipment is being used there, I think. I'm pretty sure. Okay.
2019-03.
What'd you say?
No, I'm
He's
looking
for the picture.
I'm looking at the email, see if I got something.
Yeah, it came in. So it went to submit earlier today.
Today? No, it's
Oh, earlier today. Okay.
2019. Let me hold on a second. I'm pretty sure it's in the download folder on SharePoint. 2019. Yeah, interior photographs were submitted on 1/25. Yeah, that's true.
Yesterday, I'm sorry, Monday. Today's Tuesday. I apologize, sorry.
And yesterday, yeah. And so there
Yesterday, I apologize, yes.
Okay.
Okay.
All the
That's
days
fine.
are
Thank
blending
you.
in.
Commissioner Shabeta.
Thank you. To the objector, with regard to the objector, his concerns of crowds and noise, I think that his building, the building that his residents reside in, is separated from the subject premises by another building. So I'm not sure he would have that much of a noise issue with regard to whatever's going on inside this this place. Plus, if this has been around since 2014, I don't think they're gonna, I think the concern of crowds happening perhaps in the future is not very informative. With regard to the other, I understand they stated that it was commercial, but I'm not sure, as the chair stated, whether or not this is live work. But in either event, I think that they should provide some acoustical information, because the type of CrossFit this is does have barbells and heavy weights, and we've had experience in the vibrations with that. I don't think it would hurt for the resident, the other tenants in this building to get another notice.
Right. Yes. You can actually see from the interior photos that it seems like there's just exposed metal deck on the floor ceiling.
Yeah.
So, and then this site is also adjacent to some uses. So
It's
it's
sure.
sorry, what'd you say?
It's right across the expressway, so I think that it's facing the expressway, the BQ.
Yeah. Right.
And that's heavily trafficked on both the street level and above it.
Right. So you're saying like the vibration from the BQE would overcome the vibration from dropping a 300-pound weight?
Yeah, I'll leave that to Commissioner Shetta to.
No, I just looked at I found the interior photos, and I believe that the flooring is kind of a metal steel plates or metal deck, and I'm not sure if they are dropping weights on this kind of flooring.
Yes.
Holy tromboli, it's gonna be like a scary sound. And I don't see, I can't see like any sound attenuations in the pictures. The walls appear to be like, it's just concrete blocks.
Yes.
They just painted, that you can see the lines, the spatial lines between the blocks in the picture. So it doesn't sound like there is even like a sheetrock cladding for these walls. So they need to address this concern. It's very legitimate, I believe. Nothing on the ceiling, nothing on the walls, nothing on the floor. And the weights are like really very present in the picture.
Yes.
So,
yeah, it's actually funny. I mean, steel plates, unless that's just pressed rubber to make it look like steel, because that does exist.
I haven't seen rubber like that. I believe these are metal plates.
Yeah, that's a pretty surprising approach. This must be one noisy place. Wow.
Yeah. With these kind of weights, if you're dropping these kind of weights that you can see in the picture on rubber like that, I believe they need to change it every week.
Yeah.
That should be metal. Yeah.
They have these boxes that are called rogue boxes. I think those are the things you jump on, as opposed to we've seen rogue platforms that you lay down on the floor, and then you can drop the weights. You're not supposed to drop the weights at all, but if you drop the weights on the rogue platforms, it absorbs some of the noise and vibration. But that doesn't look like what they have here.
Yeah.
And so I don't think you were involved in the case we had on 19th Street, right? That was our first experience with a CrossFit, sort of an extreme CrossFit, where the culture of the CrossFit was to drop the weights from above your head. You lift the weights up, and when you got there, you tossed them forward because they were so heavy that the average lifter couldn't bring them back down. So they went up and then you threw them and they landed on the ground, clunk, right? So, you know, you think in a manufacturing district, that's the only place where you could actually have a CrossFit. But the question is, what's upstairs and what about the adjoining uses? So, okay. Thanks, everybody. Let's go on to the next.
Item number 25, 2020-63BZ, 1718 East 28th Street, Brooklyn.
Okay, just 1 second. Sorry. Okay, we have proof of service of initial application to officials and of notice of hearing to officials and neighbors. Community board recommends approval with 1 opposed. We have 1 letter in support. We have 1 letter in opposition citing concerns about construction impacts and neighborhood character. As a threshold matter, this proposal retains all but the rear wall of the existing building and is a relatively modest addition at the rear and attic levels. The proposed addition would rise for 2 stories with a rear yard of only 20 feet. The rear yard diagram indicates that the site backs up to an open churchyard, but it's also adjacent on one side to a residence with a rear yard condition of 23 feet deep at the 1st and 2nd floors. And to just a note that the rear yard study doesn't reflect the actual conditions for that site. It shows the addition at that neighboring building being only a portion of the building. And the other property on the other side that's adjacent has a nearly complying rear yard of 27 feet, but it's not clear what the height of that imposition is, if it's 1 story or 2, because I can't tell where that dimension is based off of, because it also has a little 1-story addition. So I don't know if that's the thing that makes the rear yard slightly narrower than it's supposed to be. The new addition is reducing the distance between the existing house and the house next door at that side yard and rear yard incursion. At the 2nd floor, that portion of the incursion is for a closet. So if you were to remove that closet, and notably none of the other rooms are showing closets, but you could certainly have a closet within the rectangle. There's plenty of room for a closet in that bedroom. If that closet section were removed, I'd be okay with the proposal not setting back 25 feet at the 2nd floor because of the site conditions and the narrowness of the existing house and the fact that it's only being expanded at the rear. But it seems that to impose on the neighbors with a closet it isn't really the best for the neighborhood character. Otherwise, the floor area and lot coverage requests are in line with others on the block, and the attic is set back from both front and rear, and the same heights can be seen at other houses on the social block. It's the, top of the level of the other houses, but there's 4 or 5 other houses on the block that reach 34 or 35 feet. So, Vice Chair Shanda.
I think compared to a lot of the other projects that we do see, this ask is minimal. My only suggestion to what you are saying, alternative to the closet, maybe the closet can be shifted closer to the bathroom, and that way provide the 25-foot space along a portion of it. That way, I think the bedroom size is pretty reasonable given the neighborhood and the footprint of this building. So rather than reducing it, I was thinking, what if the closet was just shifted a little bit closer to the bathroom, and that way you maintain the 25-foot setback, at least along the closet end.
I need to look at the drawing and I'm not. So closet, you mean pull it, oh, I see. You mean slide it back.
Yeah,
So it's not in the 20-foot. Yeah, I agree with you. That would be fine. Slide it back so it's not in the 25-foot incursion, in the 20-foot incursion. You just slip that rectangle back.
yeah.
Right. That's another way of doing it. Yeah. I mean, I'm just looking at the other bedroom is the same size, is actually smaller than this one. And that presumably has a closet, though it's not drawn, right?
Right.
So there's
I'm
a-
assuming this is the master bedroom, so.
Yeah.
So I would be okay with that, but I really did not have an issue with this project at all.
Okay. Okay.
Thank you.
You, Commissioner Otley Brown,
No issues.
Commissioner Shetton.
I'm fine with the application. The only thing I was thinking of is the rear yard, if it could get to 25 feet on the second floor. But I honestly, I did look at the plans, and I believe it's tough to achieve that unless I'm not an architect, unless you, Chair, have an idea to how to achieve that, like get to 25 feet on the second floor instead of 20. If there is a way to get to that with keeping these like the layout or the configuration of the second floor not dramatically changed, I'm okay with it.
Right. So that's what we were talking about before, right? So either you eliminate the entire 5 feet of that entire bedroom, which makes the bedroom really narrow, right?
Yes.
That's why, and because this is only an addition at the rear, whereas most of the time, and hardly anything really on the top, whereas most of the time what we would see is them blowing out all the walls except for the ones they're required to keep the 50%, and expanding the house in all directions. And so in this case, it's such a modest expansion. It seemed that okay, but that's why we keep talking about this closet that is unnecessarily within in the setback, in the rear yard setback. That's why we're like trying to get it out of the rear yard, and that would eliminate some of the impact on the neighbor. Okay. Commissioner Shabeta?
Seems like a modest ask. I don't have any issues with this application.
All right.
Item number 26, 2020-25 BZ 14230 13th Avenue, Queens.
On the other hand, we have proof of service of initial application to officials. We have proof of notice of hearing to officials and neighbors. Community Board's Land Use Committee voted to approve, and the full board waived its recommendation. 2 letters in support. I think there's a typo about the address on page 1 of the statement of facts. Is it 142-13 or 142-30 13th Avenue? And is the lot area 4,165.2 square feet or 162.5 square feet? This is my request, please, to proofread your documents before you submit them to this agency, especially where there are numbers involved. Always check the numbers match throughout the documents. This application actually sounds like a classic case of a professional malpractice on the part of either the surveyor, the contractor, and perhaps the architect, attempting to be cured through a variance. That is not what the 7221 variance is for. Both lots 25 and 27 have been held in common ownership since before 1980. The ACRIS history stops then, so I don't know if there's any deeds before 1980. And until the construction of the new house that's the subject of this variance application, lot 27 had been vacant that whole time. All of that whole time, and it seems like long before that, all of the houses on that side of the street are built on a slope with retaining walls between them. So the claim that that's a unique condition or a difficulty makes no sense in this neighborhood where all of the houses on that side of the street are on a slope. The serious loss argument is that the house would have to be rebuilt to correct the problem. On the contrary, houses are lifted and relocated all of the time. That is what would have to happen in this case. So I'm not saying it's cheap, but it's probably much less destructive than removing the portion of the house that is that sits within the required setbacks. They just lift it up off the foundations. They build a new portion of the foundation and they drop it back down. It's done all the time. The statement of facts goes into a long description of case law that is largely inapplicable in New York City, where the zoning resolution makes no distinction between an area variance and a use variance in terms of the 5 findings. At the same time, the statement of facts fails to explain what the unique physical conditions about this site are that force the house to be built without adequate side and front yards, other than the fact that the contractor or the surveyor, or I'm not sure, inexplicably cited the house improperly and didn't think to check it against the drawings and survey, or perhaps it was the survey that was incorrect. It's hard to know. Given that so much of the site work is located on the adjoining lot 25, when I say site work, it's the steps that go up to the house. So that means concrete pours and things. It's obvious to me that such an error would have never occurred if lot 25 had been owned by someone other than the owner of the subject site. Arm's length owners pay much better attention to their property lines and would have stopped the work at the outset. I mean, for instance, if it were my house next door and I'm watching them lay the strings to start to lay out the foundation and to lay out the steps that are going to go up to the back of the house and so on, and I'd see that the string is actually, it's on my property. I have some sort of a marker that indicates where my property is, even if it's only landscaping, I would definitely say something. So the structural drawings clearly show the 3-foot wide retaining wall on the subject site and the required 8-foot side yard measured from the eastern property line at the narrowest point, and the front wall 20 feet from the front lot line. So I asked, did the retaining wall end up being wider than 8 feet? Because you had 8 feet to play with there. The drawing is clear that the house is to run perpendicular to the front lot line and that the western lot line is perpendicular to the front lot line. There is zero material in the file to explain the reason for the mislocated building, no letter from the general contractor who poured the foundation, nor from the surveyor or architect. There is merely a paragraph of conjecture from the applicant's counsel about who made the mistake. It isn't clear who the contractor was at the time the building was sited, but the original architect is no longer involved. They also need to provide us with the DOB approved drawings and the pre-construction survey. And I first queried myself, is there pending or decided litigation on this case? And in the process found that in 2010, I think, 2008, there was a lawsuit filed against the prior contractor. And it seems like 2011 was the last time that anything happened. So I don't know what the status of it is, but clearly they went after the contractor, and I'm just kind of guessing the contractor doesn't have the wherewithal to respond to the damage, the loss, but this is something that probably insurance would cover, something like that. Anyway, this reminds me of a case we had where a house was improperly designed where it was a clear malpractice by the architect. And it was a brother-sister team who tried to make an argument for a variance. And we were very sympathetic to their problem. However, they couldn't make a finding for the variance because it was clearly malpractice. At no point was the building, in that case, designed in compliance with zoning and code 2 maybe. And in here, it's clearly the building was improperly cited, however that was done. So from my point of view, there's no A, there's no B, there's no C, et cetera, et cetera. Okay, Vice Chair Shanda.
Yeah, I find these cases a little difficult to deliberate on because there are so many players involved in it and who's responsible for it. And it's at the end, it's the owner who is not necessarily well versed with all the know-hows of all the regulatory controls, is completely dependent on what the expert around him or her is saying, and is doing the bidding and is basically going along with it. But to find out at the end of it that there are some violations of the basic general rules and regulations of the zoning regulations. So I find these situations really unfortunate, and I'm very familiar with the brother-sister case, and I'm very sympathetic to this, to see how this can be addressed. I mean, with all that said, all the buildings around this site were built way back when, from the 1950s and 1960s. There are no new buildings really built that recently. This is the only new one. So all of the other buildings kind of benefited from not having the zoning regulation that is currently before us, and be able to build without having to worry about side yard and front yard and rear yard to the extent that this building had to worry. So they kind of followed, looked at the neighbors and said, okay, maybe, and nothing has changed, no zoning change. And so maybe this is what it is. I mean, that's what a layperson does. And it's unfortunate that the architect or others did not advise the property owner properly. But none of these buildings were built, all the abutting buildings were built in the 1955s to 1960s. This is the only one. So, I hope we can find a solution to make this project work. And in terms of the neighborhood context, if we were to go down that road, yeah, it meets it. I mean, from the street, one wouldn't know at all that it is not looking any different from its neighboring buildings that have been built so many years ago. So that's where I stand on it. Thanks.
Commissioner Ollie Brown.
So I agree with you, Chair, although I'm sympathetic to anybody who is on the losing end of a relationship with a contractor. They do have redress, and that's not coming to the board for a variance. A variance, you have to have a unique finding. You have to have the uniqueness finding, and you have to prove that it leads to a hardship. And what they've done here basically is they've started at their end result, which is what they actually built, and tried to back into a uniqueness finding. And everything they've done is based on showing that to undo the proposal is going to cost money, and that's backwards. You have to start with an as of right, show how there's a uniqueness finding that impacts your as of right negatively, and then build from that point to a proposal. And so I just think to myself that they didn't do that simply because there is no uniqueness finding here. I expected to see like completely flat land with all homes at grade, except for this one home that was like maybe built 10 feet up, but I didn't see that at all. I saw all the homes similarly situated on the same kind of an incline. So I couldn't pick out anything that was unique about this. So it's unfortunate, but I don't think they have a case.
Okay, thank you. Commissioner Shedd.
Thank you, Chair. I agree with both of you that you, Chair, and Commissioner Ollie Brown, that I don't think they do have a case here. I believe this is a construction mistake that's being done by a professional. He should have gotten insurance by them. And I believe that the path to mitigate this kind of loss, if any, to the owners, to the applicant side, is to go after whoever made the mistake, not go after the city of New York and try to get compensated for something that we have no mistake in doing it. I want to mention like two other things from the housekeeping perspective. They got us a letter from the contractor, like indicating that the retaining wall is structurally sound and it's in good condition. I'm not sure if a licensed contractor, if a contractor, even if he's a licensed contractor, can write a letter like this. I believe it should be done if it's needed by a professional engineer. The drawings that were presented to us, and again, this has nothing to do with the case, but I'm just mentioning this to just put in the record that we paid attention to that. That retaining wall drawings seem to be inconsistent. If you look at the cross sections that were provided, they provided sections for up to 6 feet, while if you look at the profile of the wall, you have, according to the profile on drawing S-2, you can see that they have sections that's up to 14 feet high retaining walls. So I'm not sure where are these sections on the drawings on S1 or on any of the other 5 drawings that they were provided to us. Just like I said, I wanted to highlight that, and I'm not sympathetic with them. If somebody made a mistake, he should be responsible for that.
Okay, thank you. Commissioner Shabeta.
Thank you, Chair. I think we all share the sympathy for this owner. So a couple of things with regard to any prior legal action. I'd like to know if there was if that case was settled or if there was funds, because if in the event that we make a decision on this case in the favor of the applicant, it could be a windfall situation, and that's not what the zoning resolution is intended for. I think the only way I could come to a determination in favor of the applicant, get through the A, is if he can show in one way or another that outside of the actions of the contractor, which by definition would be self-created because they were hired by the owner, outside of his action, there was a unique physical condition. If the retaining wall collapse was something unique to this particular property without any activity of the contractor, then that could be something that I can work off of, but you would have to show that that's unique to the area around it. I think that's a really hard hurdle, but I'd be willing to entertain it if an argument was made. And that's really all I have to say on this case.
Okay. Has his hand.
Yeah, I just wanna especially after I listened to Commissioner Shabat, I want to explain why I'm not sympathetic to this case. I believe what happened during construction is they tried to dig next to an existing retaining wall without doing due diligence and doing like a reasonable subsurface investigation, because this is a house, it's a small house. So let's just forget about these kind of things and let's proceed. And then what happened. At that time, if I were the person who's looking at the construction and doing the engineering for this project, I wouldn't say it could have been impossible for me to build per the drawings or to respect the property line or to respect the side yards or whatever criteria that you want to build to. All what it could have taken back then is 2 things, some thinking and some money. Like, I believe they did put a soldier pile and lagging wall in place to make sure that they retain the adjacent property. instead of putting this wall inside into your property or putting it like to squeeze that side yard, you could have put this retaining wall like at the location where it should be placed, and then pair the drawings. I believe what happened back then is they just panicked and they rushed to like bury the dead. Just let's get rid of that. And that's not a good attitude. If you get a mistake, that's a bad thing. But you know what is worst is to treat it incorrectly, and that's what has happened back then. And that's why I said I'm not sympathetic. If they did their homework and they treated this issue correctly, I could have been sympathetic with them. And we have seen cases before that when something crazy happened, the owner of the building or the structure under construction didn't rush to just get rid of the headache. But he slowed down, he hired a consultant who knows, and he treated the issue right. This didn't happen on this case. And that's why I'm not sympathetic.
Well, I totally appreciate that, Commissioner. And while I think taking the applicant on face value, assuming everything that the statement that they made is true, and the end result is a building that is inches off. The degree what they would be, well, I understand we have to make, the reason why I'm so sympathetic is, while I understand they have to make the findings, how much they diverted isn't a great deal. But again, we're not permitted to make decisions without getting to the findings first.
But, and I just want to add that the house is sited, the required side yard is 8 feet. That means they had an opportunity to have an 8-foot thick mess of a retaining wall. So from the property line to the house itself, they had 8 feet to play with. Even if the retaining wall ended up being right up against the house or close to whatever structure permits with respect to that, the house could have been built right at the retaining wall. It just needed to be 8 feet back from the property line. So that's the first thing. And then the siting of the house, rotating it like that, the excuse, so that, part of the problem is it seems like the applicant's counsel was sort of grasping at like anything it could think of to account for this rotation of the house, because a collapsed retaining wall would not force you to rotate the house. If anything, it would force you to shift it over a little bit. But they had room to play shifting it over a little bit, though I don't see why they would have needed to, because you had 8 feet already to play with. But the house was rotated. That actually makes no sense given what they're talking about with that property line. So, and because the council doesn't actually have any background, there's no information about the original contractor, the original surveyor, the original architect. We don't know anything. We don't know why this happened, other than someone just not paying attention. Nothing to do with the retaining wall collapsing, right? You'd start to lay out the site and you'd say, hey, wait a minute. And nobody said, hey, wait a minute. So, and I do agree that, one of the things that I was thinking, because I actually represented a client like this, was, and I couldn't tell the board what was going on. So I represented a client who had a project where the architect completely misdesigned the building. It was incredible amount of malpractice. The building was, I forget, too tall, too this, it just went on and on. The list of zoning non-compliances was really impressive, right? And so we represented the client to sue the architect in a malpractice case. And the judge, who seemed not to have a lot of experience with what a variance is, bought the architect's argument that the whole problem could be cured with a variance. So I was forced to apply to the board for a variance and also a special permit. I forget what the special permit was for, like for all of these things. And something like $1 million in legal fees later, the board decided that the variance there was no case for a variance. So then we could go back to the court and show the judge, who wouldn't believe that there was no case for a variance based on our simple say so. And we could then continue to proceed with the malpractice case. And I'm only guessing that maybe that's something that happened here, that the court in that case against the contractor got stopped, or maybe against the other architect or something, where the court said, you need to try to go cure this. And so here they are. I don't know, because they can't tell us. The court in my case was very clear that we couldn't taint the case by letting the board know that we were not, we didn't believe in the application. Okay. And the other thing I wanted to add is, even if there was some kind of an A finding about a unique condition with a retaining wall, which I don't believe at all, but let's just say, this site has been held in common ownership since probably the beginning of the site, because it used to be a large farm site, and then it was subdivided. And as far as I can tell, all the transfers of ownership traveled together, this site 25 and 27 together. And that's a standard, that makes it a very large site. And so the site size alone renders it easy to site another house or to enlarge the existing house. And that has been enough for us to say that that the hardship was self-created. So I add that. Okay.
Okay, nothing else? Okay, this concludes the public review session. We will now commence with the public hearing. So this is the public hearing for January 26, 2021, 2 p.m. session. New item, zoning calendar 24, 2019, 301 BZ, 148 26th Street, Brooklyn. This is Eric Polanik's office.
Hi.
Hi.
I'm supposed to have the architect too, but I told him I would let him know. I didn't know you'd go that quickly, so maybe I'll give him a call. His name is Mr. El Chom.
I see him in the room.
Yeah, he's here.
Let him
In the
in.
room.
Okay, thank you. So, okay, so he's the architect. He's with me today.
Okay, so you're ready to be sworn in?
Yeah, maybe I should turn on the light though. Hold on one second.
Yeah, you're a little dim. Okay, both parties, raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
I do.
I do.
Elise
Okay, please.
oh, sorry.
Sorry.
Elise Ladair from Eric Polanik, PC. We heard your comments. First, I guess we can fix the statement of facts, anything that is not right in there. In terms of noise, we share the we're in a manufacturing district, and we're across the street from the Gowanus Expressway, as was pointed out, and we haven't had any complaints since 2014. We did post, so all the tenants know. Above us is an artist studio, and the artist is allowed to sleep there at night, but he comes and goes. And we share the building with a place that fixes transmissions. So the caretaker studio is above both the transmission service area and this CrossFit. And then behind us is a commercial plumbing retail place. So we have not had any noise. So, but I do have the architect here who can tell you about the height of the building and the matting in the interior photographs.
Okay, but just before we do that, so when you an artist studio, so what I want to know is, Is it what is it? You know, is it a live-work situation? When you,
They're allowed to sleep there, yes.
yes, so
So
that's,
it's an artist who comes, he can paint and he can sleep there. He's in and out.
okay. So I would like to make sure that we have verification from that resident.
And we spoke with the client right before we got on this call, and he will be speaking to that tenant, and that tenant can provide a letter to your board.
Okay. Okay, thank you. Okay, so sorry, who did you want to have speak now?
Just if you had any questions, I have the architect on the line.
Okay, that's Mr. Elchum.
Yes.
Okay, I don't know, what were our questions? We can tell from the photographs that there is no sound attenuation, right? Those are steel plates on the ground, right?
No, they are not steel plates. Those are actually mats, rubber mats, and they are thick because, you know, the way that they sometimes they throw on that, it has to absorb the what do you call, the weight and make sure no sound, because, you know, just imagine if it's metal and they drop weights on it, forget it. I mean, the person is not going to be able to continue playing, you know.
Yeah.
Let me brief you though in terms of the description of the site.
Okay.
As far as the floors we have heavy-duty rubber pads up there. Now the height of the building is not the building, sorry, the floor is 27 feet high.
Mhm.
Next door to the gym, there's a transmit. They fixed car transmissions, and you know, they open at the same time and they close at the same time, more or less. Now the hours of operations, again, they start in the morning like 7 o'clock till noon, and in the afternoon they open till like 7 o'clock, 8 o'clock, and that's basically it. Now, in terms of the second floor, there's only one person who lives there, who's a painter. As she mentioned before, he comes and goes. He's not a study. He doesn't, you know, sleep there all the time. But again, it's only one person occupies that particular section. Behind the building, you know, there's also commercial property. There's a plumber, plumbing supply. So, you know, immediately after the adjacent property is another commercial. So between that plus the BQE, not to mention the noise that you get from that is way much more than you know, the gym itself or next door the transmission. You know, they fix transmissions up there. Now, I'm sorry. Go ahead.
I was just going to say, the thing I think we're missing is the mezzanine was never constructed, so there is no mezzanine.
They filed for it, but that never materialized.
Where are the pads and what's their thickness?
I cannot tell you the thickness, but the pads are right underneath the exercise area where they would you know, lift weights or they do other exercises. Right underneath, they have pads. I can get you the specs if you would like.
Yes, please. And also, can you show very clearly on the drawings where the pads are?
I'll be glad to do that. Sure.
Sorry, I'm typing.
There's a minor. It's not. There's on the plot plan. We have the wrong dimensions, so it's about like 6,070 square feet instead of whatever we have up there. So it's a typo.
Okay, can you correct that too, please?
Sure. I already have this on my.
Okay, great. All right, great. All right. So what we would like to see, we're going to go to the public. Maybe someone's dialed in. So let's go to the public, and then a little bit of a follow-up. There are two people in the waiting room.
Okay, this case is 2019-301BZ, 148 26th Street, Brooklyn. If you're in the waiting room, put the Zoom hand.
Yeah, so if there's one person in the waiting room whose name I don't recognize, if you would like to speak on this CrossFit gym, please raise your Zoom hand. And we'll wait to see if anyone calls in on this. But assuming that the person calling in, if you know how to raise your Zoom hand, please do so. Okay. The one thing that I really would like to hear from is a letter from that upstairs stating that they're not thrown out of bed in the morning by the sounds of the CrossFit. And then also, as we say, the specs on the pads and show their locations on the plans and correct the dimensions. Okay, and also I think there was a dimensional problem in the statement of facts. Okay.
Yeah.
But was it open in 2014? Is that accurate?
Yes.
Okay. Does it have any violations?
We paid all of them, so.
The violation pertaining to the use, they would like to see a gym over there instead of, it used to be a contractor storage up there.
Right.
So I would imagine the noise would be just as much in terms of the usage of that spot.
Commissioner, in the submission that you may have not seen, it had an updated list showing pay recently, like that everything has been paid and the interior photographs.
Yeah.
Thank you. Yeah, I saw the interior photographs.
Okay. It also had the violations paid in that.
Elevator violation as well, is there?
Yeah.
That's not the gym's fault, so that's the building. So, okay. All right then. So let me think. I think we could, assuming we get a letter that's positive from the neighbor, the rest of it is just giving us some little updates on things that we've already discussed. So I think we could actually close this. And then you tell us how much time you need to just also is Ms. Sanchez, is she part of your team?
No.
There's somebody in our room named. Okay. Okay. So how much time?
If Mohammed agrees with me, I think like a week. I don't think.
That's ample time. That's no problem. We can furnish all those information.
Okay.
Within a few
So
days.
I can't necessarily promise a hearing that gets you in so fast as a week. But, and you're not really sure about the tenant, right? When he or she is around to give you a letter?
I guess we will work on it, obviously, as fast as we can. So whenever the best date you can give us, we'll take it.
Also, as far as the tenant upstairs, a good portion of his space is above the transmission, area. So.
Then dash in over your drawing of the CrossFit where that artist studio is located relative to your studio.
I'll be glad to do that. I'll do that. No
Make it a lot easier to understand. So for instance, if his bathroom or something is over your studio, but not the sleeping area or something, that would make a difference. Though, of course, in one CrossFit case, people were feeling their coffee vibrating on the 6th floor. So it doesn't necessarily matter. But to your point about construction storage, it's true. The smashing of construction equipment and supplies weighs the same as the weights. So
we'll do that.
Okay. And Ms. Fuller, you might add that to your statement of facts, what prior to. Yeah. Okay. All right. So then I'd like to make a motion to close.
Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shepetta.
Aye.
Okay. Next item is 2020-63BZ, 1718 East 26th Street, Brooklyn. East 28th Street, Brooklyn, I'm sorry.
Good afternoon.
No.
Are you by yourself, Mr. Goldstein?
I am.
Okay. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do.
Please proceed.
Good afternoon. I listened to the review session. The only comment I really heard, and I appreciate the thought, it is a pretty narrow house, so we try to keep it relatively modest and in line with the existing home. The only question is with regard to the second story, that closet off of the master. So I tried to get my client on the phone to determine if they wanted to shift it back or remove it altogether. Unfortunately, I wasn't able to do it in the interim. But I will, in response to the board's comments, we'll either shift it back to leave 25 feet from the rear lot line along the closet portion, that like notched out portion, or we'll remove the closet altogether from the second story proposal.
Okay. All right then. Good. So let's hear from the public if anyone's calling in.
The case we are discussing is 2020-63BZ, 1718 East 28th Street, Brooklyn. You wish to speak? If you wish to call in at 646-558-8656. Zoom webinar ID number is 989-3926-3755, and the passcode is 231026. If you're already in the Zoom room, please raise your hand, your Zoom hand.
And if we admitted you to speak, someone is admitted.
Mr. Nunez is registered for the next case.
Okay, thank you. Okay, so in the meantime, Mr. Goldstein, how much time to submit?
A week or two?
Right. Wondering again. So let's say, assuming you either eliminate or move the closet back, as was discussed by Vice Chair Shanda. Both
Right.
the acceptable solutions, so just to get it out of the 20 foot setback, right? Back
Right.
minimum of to the 25-foot point, but even better if it was to the 30-foot point. But it's like moving it up against the bathroom, basically.
Right, as I can move it to the point of the bathroom window.
Yeah, there you go. So, or as long as you can get into the closet, because it's a shallow closet.
I'm gonna work on it and see what makes the most sense.
Okay. So then I think we could close this, assuming that we receive drawings that look like that.
Those will be the only changes
Okay, and you will bubble that with
with an annotated cover.
an annotated and a nice cover, yeah, the cover letter. Okay,
And a clear set,
I'll do what I can.
must be a bubbled set with chart and annotation and a clear set. Both must be submitted.
Oh, clear. I thought you meant clean set.
Clear
Yeah,
set, clean set, sorry, clean set, sorry.
I thought you said clear. Clear.
Sorry, I did say clear, clean set.
all
There
right,
must be two sets of plans.
there you go. Did you get that, Jay?
I'm with you. No problem.
All right, so then I'd like to make a motion to close.
Chair Perlmutter? Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Okay,
Okay. Thank you very much, everybody.
thank you.
Bye.
Item number 26, 2020, 25BZ, 142 30 13th Avenue, Queens. What is that? Oh,
Somebody's phone vibrated.
oh, is that what that is?
Okay.
Yes.
These cases.
It's Sheldon LaBelle. I don't know.
Oh, there he is. Okay, there's Richard. Okay,
Oh, okay.
all right. When you can hear us, please state your name.
Richard Lobel of Sheldon Lobel PC for the applicant. Good afternoon.
Is Mr. Nunez one of your people?
I'm unsure. Sheldon Lobel actually will be appearing. I'm assisting in presentation of the matter, so I'm assuming he is logging in at the moment.
Okay.
Okay. Do you want me to swear him in, swear Richard in and?
No, well, if Sheldon is presenting, then we need to wait.
I think
for-
maybe we need 60 seconds.
Okay.
Thank you. And Mr. Nunez is the architect.
Ah, okay.
Wow.
Chair, Commissioners, I don't want to waste your time, and I know that Mr. Lowell is actively attempting to log in. I'm happy to start with a background discussion and then let him join when he's on.
Okay.
Okay, let's raise your right hand. Do you affirm to tell the truth, the whole truth, nothing but the truth in your testimony before this board and respond only to board member questions?
I do.
Okay, please proceed, Mr. Lobel.
Thank you, Commissioners. Richard Lobel of Sheldon Lobel PC for the applicant. Good afternoon, and thank you for hearing us on this matter. We were in attendance at the executive session, so benefited from the board's comments. And at the end of the day, wish to have additional time to make the necessary findings with regards to the variance. So we are in agreement with many of the board's comments and in disagreement with some of them, which we can discuss. Understandably, the board has in the past and has the authority to legalize conditions on buildings which have been built in violation of zoning regulations. Obviously, an applicant would need to make their findings, but the authority of the board to legalize conditions is clear. I think I would point to Commissioner Shabetta's comments with regards to the fact that the building is inches off what would otherwise be permitted, and that the divergence here.
Oops, you're muted. Sorry, Richard, you're muted. You're muted. We can't hear you.
Okay, good. This is more than just a gut reaction to the fact that this variance is relatively minor. This is actually a matter of law, and an important one, which is the statement as supported by the Court of Appeals in matter of consolidated as Edison versus Hoffman, which is that a significant factor is the magnitude of the variance sought, since the greater the deviation, the more likely it is that the impact on the community will be severe. And this is no small point with regards to this application, because the idea that in an area variance, the magnitude of the variance can impact whether or not the applicant would benefit from a variance has been used to turn down area variances, specifically in matter of National Merit versus Wiest, which is a case that was cited and provided to the board. The applicant there sought to build a shopping center and would have required area variances, which would have allowed a building which otherwise would have been 180 feet long to go to 965 feet. Clearly, the disruption to the zoning plan there was significant, and so the board there, the zoning board, found fit to turn down that variance. The matter here before the board more closely aligns with matter of townwide properties versus Zoning Board of Appeals of Huntington. And in that case, the same case was cited, Consolidated Edison versus Hoffman. But like here, that case involved a single-family residence. It involved one where yard waivers were sought in order to legalize an otherwise illegal house. And the board there turned it down, but it was eventually overturned by the second department, which viewed the variances there as minor and essentially allowed the application to be proceeded and to be granted based on the fact that for an area variance, these were minor discrepancies and did not afford any disruption to the local zoning plans. So, you know, obviously, and I'm sorry that Mr. Lobel is not on yet, and I'm happy to discuss this as well. There's discussions with regards to area versus bulk waivers, and we're happy to discuss those, particularly in light of Justice Al Schlesinger's lower court decision in Panelides versus Board of Standards and Appeals. But suffice to say that here, we have a situation where we feel that on an as of right basis, given the conditions of the site, that the conditions here would have resulted in including the conditions of the retaining wall, would have resulted in a condition where an as of right development would have been, difficult, and the minor variations sought here should be supported. We understand the board's point with regards to the outstanding litigation and that they don't wish this to be a windfall for the applicant here. We're happy to provide that evidence as well. We have Mr. Nunez on the phone, who is the architect of record and can discuss some of the issues with regards to construction and the plans. But at the end of the day, we do know that this is these are minor waivers requested, and that we are happy to provide the additional support, perhaps given more time now that we have the focus of the board and we understand what the issues are, to be able to provide that in a supplemental hearing and to satisfy the board with regards to the waivers.
So it sounds like what you're suggesting is, in the case of minor requests of whatever nature, we should just ignore all the findings that are in section 7221, because in Huntington, where I'm just taking a wild guess, they don't have their own zoning resolution that has findings for a variance, but rely on common law. You're suggesting that we should grant all minor requests for variances without making our findings. I'm very confused by that.
Well, we do not, Chair. We actually, what we're pointing to here is, so in Foose versus Foley, as an example, in that case, the applicant there was required to maintain a 25-foot front yard for the property and built the house to 21 feet, enclosing the first 4 feet of the property from the front yard line. And in that case, the board decided against granting a variance there, despite the fact that, that this was not a major disruption to the plan, although greater than would be here. And the court upheld that decision in Foose versus Foley not to require a grant of the variance. And why was that? It was found in that case that, in Foose versus Foley, that it was a matter of personal convenience for the owner. We would never ask this board, for which we have a great amount of respect and deference, to grant waivers or variances when they would not otherwise be merited by a valid application. What we're basically saying is that the variances that are requested here are not merely personal inconveniences. And to the extent that the board requires additional support of the uniqueness factors here, and with regards to the hardships that were encountered during construction, we're happy to provide that support. We would not seek to do this lightly. This is obviously a serious matter for us, but we do not suggest what the chair suggested. We understand that the seriousness of coming to the board, and we would not seek to tread on that, the importance of that decision. I see that Mr. Lobel is here. I know I've given some of the background, but this is primarily his matter. I'd be happy to have him unmute and to take on the remainder of the case.
Okay. Mr. Lobel, you need to be sworn in also. Did you swear?
I swore Richard in, but I didn't
was
swear.
sworn in.
Mr. Lobel, Sheldon, do you want to unmute yourself? Not sure. There we
Okay, now I unmute. I'm new to this stuff. I'm not so good at it. I'm better standing up at the lectern, talking to the board. And I gotta say, Madam Chair, I've been doing this for 50 years. No one ever accused me of grasping with straws. That's not the way I practice. When I went to law school, I learned that you have to research, spend a lot of time, and do the best job possible. Rudy Giuliani just found out that you can't grasp the straws. You have to base what you're talking about on sound fundamentals. And when I saw, and I take it personally, that you would even accuse me of grasping for straws and basically not knowing what I was doing. I'll read the transcript again and I'll see what you said about me, because I prepared this case because I had heard she'll never grant it. No, no, no. I said, how can anyone turn this case down? It's a simple case. What is the Board of Standards and Appeals supposed to do? They're the
Mr. Lebe-
safety valve. They're the
Mr.
ones who are supposed to clear up problems created by this massive zoning resolution. So we're charged with doing that. So I don't grasp for straws. And you mentioned that that it's an 8-foot side yard requirement.
Mr. LaBelle, with all due respect, I have to swear you in.
Oh, you didn't swear me in yet? Go ahead. All
Okay.
right. I'll repeat myself then after you swear me in.
No, let's go to the case. But do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
I do. But did
I-
did I start out by saying anything, or you missed that?
No. I need, you said yes. So you want to start your presentation, Mr. LaBelle?
All right. So I just want to say again that I take it personally when someone, a professional.
Chair, I would,
Mr. LaBelle, let's go forward.
Chair, I would just add, obviously, Mr. LaBelle joined late and didn't have the benefit of hearing some of the prior discussion of case law. Perhaps if Mr. LaBelle can just proceed to discuss the merits of the case and the facts therein, that would be helpful.
Yeah, I'll do that after. I just always have to get in, and I'll get in, that I go back 50 years with this board, and that my father-in-law was the first director of the board, a commissioner with the board, a vice chair with the board, and chairman of the board. So that 3 generations, and I'm very proud of my son, Richard, who's picked it up from me. But we have a very simple situation here. Sue the contractor, sue the surveyor, but listen to the facts and then see whether the law almost in a sense requires a Board of Standards and Appeals to grant a case like this. And I know we also understand that there's no issue as far as I know, and as far as Judge Schlesinger decided in the Pantelides case, that there's a difference between an area variance and a use variance. Clearly, this is a very minor area variance. And I won't go over, I'll submit, if the board's not aware of it, I'll submit the Pantelides case, which my office handled, which Judge Schlesinger made it very clear when Howard Hornstein, who was a real professional, brought up the fact that he said there's no difference between a use and a bulk variance. And Judge Schlesinger said, I disagree with you, citing the Gallon case, Second Department Appellate Division, citing other cases. Let me give you the Envoy Towers versus Klein. If you read the cases, if anyone has any issue that there's not a difference between a bulk and use variance, all you have to do is read all the cases that come out of New York, which deal with the issue. I even point to the board's own resolution, the board's own rules, item 7, where they talk about the need for a financial feasibility study. Financial information is not required for applicants for special permits, not-for-profit organizations, and individuals 1, 2, and 3 family residential bulk. And that I didn't put that word in. The board used that word bulk, which also means area variance applications. So it's clear that the board and its rules recognize the fact that there's a difference between an area and a use variance. Because as the courts have said many times, you have to weigh the impact And you have to read, as Judge Schlesinger said, you have to read the preamble to the zoning to 7221 when it talks about practical difficulty or unnecessary hardship in using the zoning resolution to secure justice and relief where necessary. Now, clearly, there's practical difficulties here. Someone may suggest, well, pick the building up and move it somewhere else. I don't think that's a legitimate kind of response. How many buildings are picked up and moved somewhere else? It's tremendous, a tremendous undertaking. So what do we have? The side yard requirement, Madam Chair, is not 7 or 8 feet. It's 5 feet. We have 2 yards that violate the zoning. One is the yard on the west side, which is now owned because it's owned by different members of the family over the years. Mrs. Guarino, who wanted to be here, but unfortunately had to go to the hospital today for emergency surgery. She lived in one building, her mother lived in the other building, her son, other people in the family. They bought it. They built the original building in the 50s on the other lot. It's always been a separate lot. So they decided at that point, let's build a house, hired an architect, hired a contractor, did everything. And what happened was there was a catastrophic collapse. The building department, even when notified of that collapse, they issued a stop work permit. And then the owners hired an engineer, very reputable engineer, who put together a very detailed plan to ensure that there would be no collapse or no problem on the east side. The east side yard is over the required side yard. The west side averages about 3 feet or less at certain points. And the front yard, the architect said to us, I can probably get that even approved at the building department because it's so minimal. It's, I don't know, whatever it is, it's short by not even a foot, by inches. So what are we talking about? And who does this affect? Who in the neighborhood is affected by this? One of your commissioners did mention that you can't see this from the street, and you can't. I've been there a few times. You can't see. Who does it affect, if anyone? The building on the west side that's owned by the same family. They're certainly not objecting. They're consenting if you want us to give you a consent. So who is it affecting? Who does this little encroachment affect? So the response is pick it up and put it somewhere else. Now, I have other cases. I'm not going to take more of your time, but I think in the interest of justice, to relieve the owner of practical difficulties, we're not asking the city to do anything special for us. We're asking us to give relief. There was a case that I think was mentioned by the board about the sister and the brother. And in that case, if it's the same case on Staten Island, there was a major intrusion, 16 feet, 15 feet. And the board pointed that out. And I'll send you that case also. That makes a big difference. That may affect the question of because as the cases say, don't only look at self-created hardship, look at all of the other findings that you have to make, which go into whether you should relieve this self-created hardship. Now, I'm sorry that I get so worked up about this. I've always gotten worked up about zoning issues and trying to help people because I know that's what the board should be doing. And I hope that you can understand that I have people here who live with this, have tried every other way, gone back to the building, and the building department rightly said, you have to go back to the board on this. We wanted to see if the building department might issue this. They used to have a 1-foot rule or whatever, but no more. So we came to the board. I'm not grasping for straws. I'm trying to be as helpful. That's why I haven't argued a case at the board for 5 years, but I wanted to help these people and we went to the community board. or before we filed. And they said, why are you even coming to us? I said, well, I want you to know what we're going to be going for. And they waived their hearing because it was such a minimal request. So thank you all for listening. I apologize if I'm a little emotional, but I think in the interest of justice, which is what we all should be concerned about. I know we have technical rules, but in the interest of justice, should you turn these people away to do what? To move the house somewhere? To destroy a building because of a mistake that was made? It is a mistake. There's no question about it. And also, I thank you for listening to me. And if the architect might want to speak and conclude the matter, thank you.
Thank you. So just as a reminder, we have findings. We need a unique physical condition. We have an as-of-right drawing that shows the house in the right place. We have approved Department of Buildings drawings that shows the house in the right place. We have a problem where the entire lot is owned by a single owner in common, et cetera, et cetera. All of those things need to be pursued. I remind that the Pantelides case was a detrimental reliance variance case based on the idea that the property owner made a change to their building based on approvals from the Department of Buildings, which were reneged. That's the famous Pantelides case. That's the issue there. This is not a detrimental reliance case. And as a result, an A finding needs to be made, a unique physical condition.
Yes, respectfully, Madam Chair, that is part of the Pantelides case. That was my case, including Ellen Tuck versus Klein 30 years ago, which was set the standard for reliance. But the Pantelides case did deal with reliance, but the major issue, as raised by Howard Hornstein, who was formerly a commissioner at the board, a knowledgeable zoning person, he raised that issue. He says 7221 doesn't make a distinction. Judge Schlesinger, Alice Schlesinger, God help her, she made a decision, and she said an area variance is different than a use variance. She was very clear. She had a separate paragraph, cited Gallon, cited the other case that Envoy Towers, cited Bronxville. So I'd like you to read that case again. I lived it, and I read it 26 times and told people in my office about it, because I think it set the rule, which should be the rule. An area variance doesn't affect the neighborhood generally, unless it's so big that it's going to create an extra apartment or do something that might have an effect. But read it again, and then hopefully you might agree with me. And so we'll get this out of the way, because I don't believe that people are looking. There was a chairman of the board, Sylvia Deutsch, who decided one day, under pressure from city planning, I might say, who decided that Mr. Lobel, Bulkin uses different. Subsequently, I met her and she says, I'm sorry I did that because I saw you were trying to use what the state has done with the adoption. But so it's clear that there's no question, an area variance, and that's what Judge Schlesinger pinpointed in her decision.
Okay.
That's all I have to say.
Okay.
I've said too much, but
stand. We need to make the findings.
No, right. But you have to.
Okay. I also have a comment.
You have to make the findings in conjunction with the rest of the preamble, so that substantial justice is done.
Okay, so
that's what Judge Schlesinger did. She read the preamble and she's.
Okay, so I have a question/comment about the discussion that we've been having. The 1961 resolution that was promulgated by the city clearly sets forth 5 findings that must be made. The self-created hardship legislatively overrides the common law standard that existed at the time. The question for you, I think, in this application is to what extent did the City Planning Commission and the City of New York override the prevailing standard, the common law standards applicable to zoning variances throughout the state of New York? We know that it basically codifies the Otto v. Steinhilber findings. However, the text, unlike in other areas of New York where we see specific delineations in the text between use variances and area variances, the drafters of the 1961 zoning resolution instead opted to have the same standards applicable. And we see that in 7221A through E. And so this, I think, is an important question because obviously when we're looking at a statute, the main purpose in analyzing the text is to achieve the legislative intent. And so to the extent that the codification of subsections A through E of section 7221 of the zoning resolution evinces a legislative intent to apply the same standard to area variances, so-called area variances and so-called use variances, then that is what the board should be applying. And as I understand it, that is what the board typically does by treating these the same within the city of New York. And the thing that's very important about this is that the Otto v. Steinhilber decision came out in about 1940. And then we saw through the common law that I think it was the Bronxville case, but I'm not sure, but it definitely predated the 1961 zoning resolution. So we saw that there was already a split in the common law by the time the drafters of the 1961 resolution were promulgating that or enacting that legislation. And so if your thesis is that the 1961 zoning standards for variances are not the same, then why is the text the same? And I think that is the path of research that would be most helpful.
I'm sorry, I don't know who's that speaking.
Our general counsel, Skirt.
Oh, general counsel. I thought that was Kurt.
It is Kurt. He's our general.
Oh, Kurt, yeah, he was the one who wrote that about that glowing decision and on the on that case uptown where they had the open space issue.
So if I could just add right now, Kurt, we appreciate the point. I think that
but I must add this.
Referring to the statement in Pantelides, we can basically restate it, but essentially where Justice Schlesinger notes the notes that the preamble for 7221 mandates that BSA grant variances so that the spirit of the law shall be observed, public safety secured, and substantial justice done, and uses that language to essentially establish that while 7221 discusses the 5 specific findings, they must be made consistent with the mandate, and as such, broadens that to provide that the larger body of case law distinguishing between area and use still holds.
Yeah. Okay. And I'm sorry to interrupt my son.
Please,
but
may I please? I think that basically we should take the opportunity to brief the board on that, and we're happy to answer that in papers because this is something which is controlling law and which we're happy to provide that to the board.
Okay. I know sometimes you say I talk too much, but I want Kurt to think about that. The 61 zoning did lump them together. Judge Schlesinger, read her decision 30 years later, upheld by the Appellate Division and the Court of Appeals, where she said, I disagree with you, Mr. Hornstein. 7221, you have to understand that there's a difference between a use. So read the 61 zoning and then read Judge Schlesinger's opinion, upheld by the Appellate Division and the Court of Appeals. So when I went to law school, we understood that a Supreme Court judge can, that's the law of the case, especially when it's upheld by the Appellate Division and the Court of Appeals. So that followed 61 zoning. And she said, the law is that you got to treat them differently.
Well, I guess the only thing I would say is that opinions can be upheld on other grounds. And we've also had recent Supreme Court decisions where they're applying the town law within the state of New York. So I'm not sure that how persuasive that argument is, but
Well, I wish you would read Pantelides. That's all. Read it
Okay.
carefully.
We will read it as we have read it many times before, but I also am thinking, without looking at the case at this very second, that the importance of the Pantelides case, which was actually a very interesting case, was that it opened up the possibility of detrimental reliance on these kind of small situations. Whereas the, what was it called? Park, the Park, whatever, 96th Street one, the Park West case, I forget what it was called, basically said that the Department of Buildings is stopped from allowing any kind of essentially a detrimental reliance, and so therefore, and that was sort of the law of the land until Pantelides that opened that up. And
No, they in that case on 96th Street, they quoted my case, Ellen Tuck versus Klein, which set the standard for reliance. But it was a whole different case there. The map said one thing, they were told, and there was also the building code at that time also said that if you get a stop work order, you can continue building at your own risk. That's not in the code anymore. They changed that. Now you can't, you got to stop working. So the owner in the 96th Street case said, listen, I'm going to continue working. And because the statute says I can continue working, I'll take the risk. And it was completely different. And they relied on, and remember, the law is from Ellen Tuck, in good faith reliance.
Right. Let's not talk about the reliance case. I'm just suggesting that that may have been where Judge Schlesinger was distinguishing area versus bulk in terms of detrimental reliance. But I don't want to I don't want to go on about detrimental reliance. But we still do have to make our
right. You have to make your findings in line with the preamble, which is what Judge Schlesinger said.
Board, you can brief this, but you hear skepticism on the part of all of the board members. And I do want to add that according to this theory, lots of illegal construction and we see a lot of it come to this board, lots of illegal construction should be cured by variances because contractors don't pay attention, or architects don't get hired for site supervision, or do get hired for site supervision and don't follow through, and on and on and on and on. And the board is not here to cure malpractice action and other types of malfeasance on the part of construction companies.
I understand that, but as your case, I think Juo with that Staten Island case distinguished that case because they said when the two commissioners went to visit the site in Staten Island, they can see the intrusion into the 16 feet, 18 feet. It was different. That's what the cases say. You know, you can't take a self-created hardship by itself.
I think that was the case that the chair was referring to.
No, it's not the case. Oh,
no, that was not the case.
Because there is a case that I found that in Staten Island. As a matter of fact, I called former Chairman Shirin Sasson. She didn't remember the case, but the board made a distinction. They said, in this case, they said, we can't ignore it because it's 16 feet. It affects the character of the neighborhood. Who's it going to, it doesn't, we don't want to just benefit an owner and screw up the plan for the neighborhood. This doesn't screw up anyone.
Mr. Lobel, I think you've made your point. I'd like to hear from Commissioner Sheta.
Okay.
Yeah, I just wanted to mention that.
Sorry, I hit the mute button. I'm sorry, unmute yourself.
That's okay, that's okay. I was like staring at the drawings since the beginning of this case. And I'm not sure what kind of difficulty exactly that existed back then when this retaining wall collapsed. If the response is going to be, it was very difficult to build close to that collapsed retaining wall, and that necessitated that the building could be shifted in the way it shifted, I would respond to that. Why wasn't it possible to just trim part of the building and just build it with shorter facade? That could have resolved the issue immediately and eliminated the need for all the discussions we're having and for this case at all. So I'm not sure, unless there is something material that could be presented to us on a case like this, I can't see any like uniqueness there. I can't see any hardship at all. I can't see any practical difficulty in abiding with the zoning resolution, which is the law of the land so far. This is our law.
I know. I mean, I think zoning is wonderful and you have to comply with it. But sometimes people, if they really do something bad and it really is going to affect the neighborhood.
Okay, I don't want to keep going on with that point.
Right, yes.
Up with perhaps Mr. Nunez can shed a little bit of light on this because
Okay,
we
yes.
continue to be in total darkness about what happened. And I don't know whether there is litigation against the surveyor, the architect, the status of the litigation with respect to the contractor who made the site. We need to understand that. I understand Mr. Nunez is not the original. So please go ahead, sir, Mr. Nunez.
Yes, hi. I'm not clear what your question is for me. I'm just doing the drawing for the BSA, trying to help correct this problem. I'm not familiar with the previous architect's reasoning behind what happened here. We do know that the situation with the retaining wall was a factor in why the building was built the way it was. Something I believe I was told that the wall was being constructed and repaired as an emergency while that building was being constructed. Again, I can't say why it was changed.
Right. Okay. So the part of the problem is, you know, if there's going to be some argument that something, and this is not for Mr. Nunez, this is in general for council. If there's an argument made that something very unusual happened on the site, we have no idea what it is. We have a sentence in the statement of facts that said something unusual happened at the site that had to do with the retaining wall, but no one to give testimony about what actually happened, no drawings, no photographs, no nothing to show us. And so it's based on one sentence of somebody made a mistake and we're sorry. Yeah, you know, and by the way, the difference is not a foot, the difference is 3 feet on the side yard.
Yeah, thank you.
Almost 2 feet on the front yard. So, you know, it's not an immaterial difference. And the reason that the buildings department wouldn't allow it is, well, for one, if they have a 1 foot rule, they don't have a 1 foot rule anymore, but we have seen them allow certain kinds of errors in citing. And they obviously consider this error material. So that's why they wouldn't sign off on it. So
No, they consider, Chair, they consider it because the board has complained to the building department in the past when they act on something that should go to the board, because they've seen cases where the board acts and then the building department says, why'd you allow them to do it? Well, people say, why'd you allow them to do it? So typically they'll say, go back to the board. That's the agency that grants relief.
right. Well, not always. Okay. All right, then. Is there anything else that you wanted to add? I think we've made the points clear.
Yeah, Chair, the only other thing we would add, and again, we thank the board for the opportunity to bring this application. We will provide the board with the additional materials as were requested and provide photos and testimony with regards to the full record on what happened at the site. You know, we are obviously, we recognize that the board is not able to grant based upon, you know, the mere hardship of the owner. You need to make your findings. We get that. We would only add that, I have benefited from Sheldon's knowledge with regards to case law. I have done my own research with regards to this matter. The only thing I'd add, and again, we'll brief the board, is that self-created hardship alone based upon the cases. And there are obviously a number of cases which deal with single-family homes and zoning relief that self-created hardship alone would not be a sufficient basis upon which the board could rely in order to deny an application. So much like the language already contained in 7221D, the cases support that in the event that the other findings are particularly compelling, that inability to make your D finding wouldn't necessarily mandate denial of an otherwise valid application. But
So, I just want to interrupt there. We have had long discussions about this.
Sure.
I need to pull up the language of 7221, but my question of this is that 7221 says purchase of the site that already has the hardship is not enough to be counted as a self-created hardship. It doesn't say that if the hardship is self-created, it doesn't invalidate the ability to experience. So we have actually made decisions where arguably they could have made the other findings, but the hardship complained of was so clearly created by the owner or predecessor in title that we denied the variance. So I disagree with your
understood. Chair, we've had these arguments before the board and before you. The text provides that the practical difficulties or unnecessary hardship claimed as a ground for a variance have not been created by the owner or by predecessor in title. However, where all other required findings are made, the purchase of a zoning lot subject to the restrictions sought to be varied shall not itself constitute a self-created hardship.
That purchase of the lot.
Understood,
Right.
Chair. The only point.
It's not purchased subject to.
Understand.
Created hardship is intentionally citing the building the wrong way.
Understand. Well, I think we'd make 2 points. The first is that the conditions complained of would not constitute self-created hardship. We understand that these conditions are now at the property, but that other applications before the board which have involved legalizations have not been found to have violated the D finding. That's really the only point we're making, that the conditions that we're complaining of here are endemic in the property itself. Again, a factual matter which we will demonstrate to the board. And we would only add that the case law does have this chain within it, which is that, particularly in area variances and particularly for one-family homes, that self-created hardship did not defeat, using the same text and same language, would not defeat an otherwise valid application. Again, not a point that we wish to belabor right now, but one which we will raise to the board in our papers.
Commissioner Otley Brown, you wanted to say something? You're muted. You're muted.
Who's that?
Doesn't that statement more refer to like when a purchaser purchases a lot, for instance, that's undersized and then makes the argument that it's undersized, that doesn't count as self-created? Isn't that what that portion of the language refers to?
In the D finding that was quoted, there is a discussion of purchase, but again, we will brief this to the chair and to the board. As we've done many times before, in this case, we don't feel that the nature of the hardship here was self-created, and that arguably, if it was, it would prevent the board from granting the requested relief here, particularly in the case of a minor area variance. We understand it's our burden.
Yeah. So understand that I don't want this to just drag on, because at the moment you have some very skeptical commissioners. So I'm going to say that there's one submission on this, one hearing on this further, and then we're going to close it, okay?
Madam Chair, I don't think that's very fair that you're limiting it to.
Mr. Lobel,
Yes.
I know it's hard for you to accept, but I'm the one who actually manages the hearings. And
No, but I could, I mean.
Lobel, please don't interrupt. When I see that all of my commissioners appear to be in line, then I don't want to waste their time. I don't want to waste your time. And I want to make it clear that you have one chance to make this argument stick. And
Okay.
otherwise we will close and make a decision on it. Okay. I see one person in the waiting room who might want to speak on this, and I'd like to invite the public to speak. Tony?
This case is 2020-25BZ, 14230 13th Avenue, Queens. If you want to speak, it's 646-558-8656. Zoom webinar ID number is 989-3926-3755. Passcode is 231026. And if you're in the Zoom room already, please raise your Zoom hand to speak.
So there's a Mr. Wright in the Zoom. Oh, he's actually in the room already. If you would like to speak on this application, please raise your Zoom hand.
It's 2020-25BZ, 14230 13th Avenue, Queens.
I think he's not yet. I'm allowing him to talk. Because
Also, Mr. Lobel, when you're briefing these issues, if you could include discussion of the case Chera v. Bennett, that's CHERA v. Bennett. It's the Appellate Division, Second Department from 1990. And this was a case where it appears that a homeowner erected illegal additions, and it specifically speaks to what you were saying about self-created hardship, but it says that it is a significant factor militating against granting the application, particularly where, as here, the hardship results from simple disregard of applicable zoning regulations. And so this was a request for an area variance as well, and the board denied it, in particular based on the failure to find unique physical conditions and resulting in practical difficulties or unnecessary hardship, and the lack of substantial impairment of adjacent property test. So that would be an important case to look at.
Is that Chera, C-H-E-R-A?
C-H-E-R-A.
We're familiar with the case. We briefed it before. Happy to include it in our materials.
Thank you.
thank you.
I would also mention, just in conclusion, that someone should look at the A finding, which is the uniqueness finding, which always takes you into the B finding, which is the reasonable return. But in a one-family house, the board has said you don't have to file a financial analysis. It's right in their rules, item 7.
We're not asking for a B finding. We're asking for an A finding. And so far, we don't.
No, but 7221, if you want to go back to 61, says that A takes you into B, that it's unique and that affects your reasonable return. So, but the board has said that we don't have to file any financial analysis. So doesn't that?
So you're saying that because there's no B finding necessary for a single family home, there should be no A finding? Is that what you're saying?
No, I'm saying that there should be an A finding, but only if it directs you because of your uniqueness, then you can't get a reasonable return. But the board has said, don't file any financial information to us. So how, there's nowhere to go from A to B. That's what I think, but no one ever, whatever, that's another thought. Okay. But basically, I think someone should read the Pantelides case, and we'll read the Chera case, but I'm sure we'll find.
I believe the reason we're not asking for a financials or construction cost and these kind of requests on a single family house is because it's a very simple project, and that's why we don't want to put burden on it. But it's not because we're like abandoning one of the findings or something like that. It's because of the simplicity of the case.
Right.
All right, that's good. That's so now you have a simple case then. Thank you.
Let's not get into that. This is a long board practice where financials aren't relevant, where it's a single family home, where most of the time the variance requests are for, and they're asking for something to make the house livable. And so that's what we're at, right?
You mean the special permits? That's a separate issue.
Mr.
This is
LaFleur,
not-
please don't interrupt. I know you're not used to working on the Zoom calls, but please don't interrupt while other people are speaking. I want to hear from Mr. Wright, who called in, unless he doesn't want to call and called in by mistake. You're permitted to speak, so please unmute yourself.
Can I be heard?
Yes. There
Yeah.
you go.
I'm sorry, I'm not in the right hearing,
Oh,
so
okay.
I'm just listening on
Okay.
this one.
Sorry. Did you miss something that you wanted to give
No,
testimony?
by the calendar, you haven't gotten to it yet.
Well, that case has been adjourned, Mr. Wright. If you're calling about Throop,
Yes,
oh, that case has been postponed. They didn't do proper notification.
okay.
Okay, so let's see, maybe what you could do, how do we let Mr. Wright know about the new hearing date?
He could email me, tmatthias@bsa.nyc.gov. And you
I'm
could,
sorry, you went too quick for me.
T as in Tony,
Uh-huh.
Matthias, Mattias at BSA, Baker Sam
SA.
Apple,
Wait, SA,
At bsa.gov,
.nyc.gov.
bsa.nyc.gov,
NYC.gov.
right? You heard,
T. Matthias at CSANYC.gov.
BSA, B like boy, S
Oh.
like Sam, A like apple, bsa.nyc.gov.
Okay. Thank you so much. I'm sorry to have taken time. from
No,
your
that's
hearing.
okay. And we'll email you when the next hearing is, but you also get a notice if you're a neighbor.
Thank you so much.
Yes.
You're welcome, sir.
Okay. Have a great day
You too.
and continue the good work.
Thank you.
And so it means no one called in on this application. Okay, so how much time do you need to amend your statement of facts and your legal brief?
Sheldon, I defer to you on, for provision of the additional materials about the site conditions as well as the legal brief. Chair, I'm not getting a response, but I'd say probably 4 weeks would be required.
Okay, I'm going to give you more.
Okay.
Right, thank you. We'll let you know when it's scheduled. Okay.
Okay.
Okay. Thank you very much.
Chair, Commissioners, we appreciate it.
Thank you. Good night.
Thank you, Mr. Nunez.
Okay, this concludes the public hearing for January 26, 2021, 2 p.m. session.
Thank you, everyone. Good night.
Good night.
Thursday.
That's right, Thursday for a public hearing, yes. Special hearing on Thursday.
It's just